Good afternoon. I'm broadcasting today live from Wrigley Field. You can see the wall. The ivy is dead right now, unfortunately, but you can see the wall behind me. So, going to talk a little bit about new update in terms of the Tornetta case in Delaware against Elon involving the Elon pay plan. Not legal advice. Like, subscribe, share, comment, share a lot if you could. Um, Before I start, 8 vowels, 11 consonants, and a exclamation mark walk into a courtroom. They're due to be sentenced next week. Why did the elephant lose his legal case? Because his arguments were irrelevant. And last but not least, there's a new sushi bar that just opened for lawyers down the street. It's called Sosumi. Anyway, so to those of you who have been following, there's a pay plan litigation that's pending in Delaware. Right now they're waiting for a decision on the attorney's fees that would be provided. The underlying decision of the court rescinded the grant of options, which would turn into his shares to Elon Musk, relating back to the 2018 pay package. Since the ruling of the court, there's been a proxy or a preliminary proxy statement that was sent out by Tesla management, basically with the intention to restore that pay package. Now, of course, that would be 5 years or 6 years later. So it's not exactly the same package, even if it is the same package, because Elon would not have the opportunity to exercise those options for some time later than he would have originally. But see, be that as it may, what the attorneys for the plaintiffs, and again, I believe this case is all run by attorneys at this point in time because they have the most interest in this case because they're seeking a large amount of attorney's fees, approximately $6 billion based upon the share value at the time they sought it. We shall see. So their basic position is that you can't attempt to circumvent the ruling of the court by a subsequent ratification. So they're saying that the court has indicated in their decision that there's a final ruling as to the issue of the rescission of the option shares, and that any attempt to circumvent that ruling should not be permitted. And their position is, by the board now assenting to the pay plan and going forward with that, that is an attempt to circumvent the ratification. Because of that, what they're seeking is that the shares, they think the shares, but I guess it would be the options, they want it sequestered or put in a trust, put aside, so that they will always be there for collection purposes, and they will always be within the jurisdiction and control of Delaware, because that's where they are now. Now, I would say that the request at best is premature because we don't even have a final judgment yet. That's clear. There's a ruling as to the rescission. It doesn't prohibit any future pay plan. In fact, to some degree, it suggests there will be a future pay plan because it analyzes the current pay plan on an issue of fairness, overall fairness. So it didn't say that you can't get a pay plan, and the ruling to this point in time didn't say you can't get a future pay plan. It just says that what was provided at that time under the circumstances did not meet the overall fairness plan. That was the ruling. The ruling as to attorney's fees is still up in the air. So I believe that the purpose of this filing, again, to sequester, to set aside the shares, is more of an attempt to prejudice the court, the judge, against Elon and Tesla, because there's no real harm going to be accomplished if there's no sequestration of unexercised options. I don't see how that's a real risk to plaintiff, but it is a choice and a chance before the 513 meeting in Texas for plaintiff's counsel, in this case, to throw it at the judge and try to influence the judge, and also perhaps to try to influence the vote, because they have the most to lose, because attorney's fees will control this entire matter, or to a large extent. To the extent there's a large award of attorney's fees, then that may impact the strategy, future strategy of Tesla. If the award is smaller, then that might also impact the strategy, might result in a smaller award, a payoff, some resolution, insurance, etc. So what's I think trying to be done is the attorneys who are plaintiff, who are trying to get the largest award possible, are trying to paint Tesla and Elon in a further negative way, and the board in the further negative way, and trying to challenge the judge to take them up and not letting them circumvent her decision. I think, again, it's premature, again, until even the discussion of this issue is premature until the attorney fee award is decided. And that has changed slightly because the timing on the motion changed with this filing or prior to this filing. So the opposing brief by Tesla will be filed on or before June 7th. And this is relating to the attorney's fees. So there was an issue that the rescission was decided, but the attorney fee award has not been decided. So on May 8th, I believe, Tesla will be submitting reports from their experts that will deal with, is this award proper? Did they generate benefits, etc.? I'm speculating as to what it says, but it'll be the basis or the underlying basis for their opposing brief, which will be filed on June 7th. There'll be a reply brief to that filed June 21st. A hearing on the attorney's fees will be July 8th. I would estimate a final judgment, complete final judgment. Earliest you'd see that would be August 7th. If that's when it came out, a notice of appeal would be filed on or before September 6th. And then a resolution of this underlying dispute. If it went all the way up on appeal, there was no resolution, you could figure 12 months plus or minus from that September 6, 2024 date. So I believe it's premature. I think it's a transparent attempt to just cause prejudice so that the judge is more likely to rule for a greater attorney fee award against Tesla and Elon. It also suggests that the judgment or the remedy that they sought perhaps did not provide them the means from which they could assert a large attorney's fee award. So to the extent it was a monetary award and they saved a certain amount of money, then you could figure out and equate that with a benefit. Here, they elected not to seek money. They elected to seek shares, but they didn't forbid or request that the right to a pay package be canceled. Probably an error on their part, because if the right to the pay package had been canceled, then they could assert their right to the benefit because they would have saved, arguably, Tesla X amount of dollars in those shares. But they didn't. They just temporarily delayed that. I think a mistake on their part. We'll see how the court, or more likely the appellate court, sees that. On top of that, they filed at the same time in a separate filing, they filed a request for an injunction to stop any future hearing on the ratification of this pay package. So what the proxy statement that's outgoing now that'll be decided on or before June 13th at that meeting in Texas, it attempts to do a ratification. So using the same basis as they said before, they don't want plaintiff's counsel for any issue regarding that ratification that is ongoing to be decided outside of Delaware. They basically say, they would succeed on the merits. There's already been a finding about breach of fiduciary duty, etc. And therefore, they want a ruling that any issue relating to ratification has to be decided in Delaware. Again, I think it's premature, and certainly, even if something was decided outside of Delaware, if it involved Delaware law, then they would apply Delaware law. So, for arguably speaking, and in fact, in the motion, they say that in Texas there's a general bylaw that says breach of fiduciary duty claims involving Delaware or with regard to Delaware entities had to be decided in Delaware. So I really don't understand their concern. But if in fact there was an issue regarding the Delaware interpretation of ratification, that can be decided in another state. So I didn't really understand, other than the fact, again, trying to prejudice the court against Elon and Tesla, trying to give a message and suggest that it's not right to move outside of Delaware. And again, there was one case, and it'll be interesting how this plays in. There was one case recently, forgot the name of the company, but they were attempting to move from Delaware to Nevada, reincorporate. There was a lawsuit filed. There was a large shareholder who controlled the company. And the judge, different judge, said, I'm not going to stop the move. Although he did indicate there may be some basis by which I could, didn't define it, but didn't stop them. So I don't know if this is going to be another attempt at that. I can't make predictions on the outcome, but I would think it would be problematic if the state tried to block companies from moving outside their state without any recourse for the company. And obviously, the way that companies or states might be able to retain companies like this is they could change the law of their states, just like the reason why companies went to Delaware in the first place. They found the law in Delaware favorable. So now, if it's not, Delaware can change the law. So I think both applications are premature. I think both are blatant attempts by the lawyers to perfect their positions, to generate as high a degree of an award as they can, and to influence the judge pre-ruling that Elon's team and board are trying to circumvent her ruling. And by the way, even if they were, if it's a legal and permissive move, that's done all the time, and there's nothing wrong with it. If a judge says, don't do this, but you do something else in a different way, then that's permissible, even if it's an attempt to circumvent the judge's ruling. So I think both of these are taken in bad faith, but I don't know how they will be ruled upon. I think they're requesting a ruling prior to June 13th, ironically. The court could, I don't see any compelling reason why they should, but if the court is so inclined, they could do what they want. But I think it would be a poor ruling if they decided to grant these at this time under the current circumstances. And obviously, they could renew these later on if circumstances change. So if it were me, I'm going to deny both without prejudice. And if you want to bring them at a later time, then so be it. But I'm going to deny them both. I don't think they're well taken at this time. So, but that will be front and center now, and Tesla will file an opposition to this. So we talked about the attorney's fee motion. There also will be opposition filed to this particular matter. I would expect it to be filed within the next few days, and it will address some of the things I just mentioned in terms of why you're doing this. Isn't this premature? We're acting in a legal capacity, etc. So hope that helps. Take care. Be well. Talk to you again soon.